Welcome back to Tort Talk with Joe Fantini, Jon and Marc. We're here today. It's August 19th. We're talking about all the latest updates in mass tort litigation happening across the United States. Joe, first off, congratulations. You're now a married man.
Thank you.
Joe is coming from us remote. From where are you, Joe?
I'm coming to you guys live here from Aruba. Got to bring the latest mass tort updates to the people, of course.
First thing we're going to talk about today is the rideshare MDL, or the Uber MDL specifically, because it really is just the Uber cases. We've got over 2,500 cases pending in the MDL. The bellwether process is moving along. What can you tell us about this litigation for those who are either in it or looking to get into it?
Uber MDL has been a hard-fought case. The defendants fought every step of the way. They tried to get the MDL kicked out because they said that it wasn't proper. They then argued there was a clause in the rider agreement that prevented the MDL from moving forward. We're able to beat them back each step of the way, and finally we have a bellwether case scheduled for trial in the beginning of December. So how it's set up is there's an initial bellwether case, then there's a backup case in the event that that initial case settles, and then we're going to move on to the next wave of bellwether cases. So we'll see if this trial case actually happens in December or if Uber settles out. But we should have a lot of action towards the end of 2025 and hopefully a settlement in the beginning of 2026.
Pretty soon. Litigation has been around for a little bit. There's also separate consolidated cases in the JPML in California. There's also litigations against Lyft, which I think are all one-off. Can you tell us about the differences between all these different actions that are happening across the country between Uber and Lyft?
Yeah, like you said, the litigations are separated between Uber and then also Lyft. We were talking about the Uber MDL. As you mentioned, there's also consolidated state court action going against Uber in California in the JCCP. That's moving along at a pretty similar pace to the Uber MDL, so they're kind of moving neck and neck. The Lyft litigation is its kind of own entity and has a lot less cases, but that litigation's moving forward as well. But most of the action and attention right now is in Uber with this trial date set.
With the Uber sexual assaults, there's this spectrum of issues that people have had in the rideshares. So we've seen that some firms are only taking like the rape cases. Some firms are taking cases that, people are exposing themselves, the drivers are exposing themselves to the passengers. There's situations where women are getting locked in the car, but not touched. Where do you actually see sort of the cutoff being in terms of the egregiousness of the claims that may wind up being included in any sort of settlement down the line?
Yeah, that's a good question. Those are all very serious issues. But what we're seeing, and it sounds like Uber's taking most serious right now, are the cases involving some sort of physical touching. So the ones you're talking about a little bit about the exposure or maybe the temporary kidnapping, obviously very serious. We want to hold Uber accountable for that. But the bellwether trials, those cases are getting worked up, all involve some sort of physical assault, some sort of touching. And it seems that's where the attention of the litigation is right now.
It seems like Uber is fighting as hard as possible and putting a roadblock up as much as possible during this MDL. Is this common, and do you really see them settling out with this tactic in place, putting up roadblocks in every possible opportunity they have?
Yeah, this is the hardest I've seen anybody fight against an MDL. Like you said, when we had the JPM form, they fought that right away. They said that couldn't happen. When we moved the cases along, they relied on this clause in their rider agreement that was found invalid. They appealed that up to the circuit court. They lost again. They've been really fighting that hard, and they've made some changes along the line here to their process. Now they allow women riders to select only women drivers. So they're really trying to limit the potential liability. And right now I haven't heard a lot about momentum to a global. I think maybe 1 or 2 or 3 of these cases are actually going to have to go to verdict. But there's a little bit more time, I would say, before we hear some sort of global resolution.
All right, moving to the next one, barred PowerPort MDL. The MDL was before Judge Campbell in the District Court of Arizona. We have our first bellwether cases identified for trial. What should we expect in the next few months?
Yeah, so this MDL has about 1,800 cases, so it's not one of those huge ones or a legacy case. Jones Campbell, like you mentioned before, we've previously been in front of them on some of the IVC litigation, so we really use that experience of dealing with the parties to really streamline the case and move it along pretty quickly. We have the first bellwether case, Cook, is identified for the first trial case. Right now, it looks like that's going to be in either February or March, but in the next few months, we have some huge rulings and decisions coming down. We got the expert reports being served from each side. We're going to have the Daubert hearing, and then we'll really know probably in the beginning of the fourth quarter what type of claims are going to be able to move forward. If you remember with the IVC filter cases, we had a lot of trouble with maybe some of those less severe cases, the injuries that didn't involve a fracture or an injury to an organ. So we're kind of trying to avoid that long drawn out process that we've seen with some of those IVC cases. And that's why I think you're seeing the numbers down under 2,000 in total case count.
It should be a pretty exciting end of the year with lots of updates with this moving along at a pretty fast clip here.
Yeah, we'll know by the end of the year what injuries are really going to survive and are going to be compensable. And then hopefully we get past Daubert with our experts, which I think we will. And then we'll have that trial set, like I said, first quarter of 2026.
Excellent. Moving along. It's nice to see some progress in some of these cases. Speaking of progress, over the past week, we did see two big rulings come down in the weight loss Ozempic GLP-1 MDL. The first ruling was on the defense's motion to dismiss, and the second ruling dealt with proof needed for the gastroparesis claim. Can you give everybody a recap of what happened in that litigation this week?
Yeah, huge rulings came down, like you said, John. Basically, we're over 2,000 cases, and about 95% of the cases deal with gastroparesis injuries. So we have almost 2,000 total of those pending in the MDL. Basically, what ended up happening was the judge just ruled that there needs to be a certain stomach emptying study conducted to prove the diagnosis of gastroparesis. So a clinical diagnosis without this study no longer seems viable. Plaintiffs are likely to appeal that ruling up because that standard of proof is pretty high. But it gives you a good idea of some of these other injuries we were talking about, say stomach paralysis. Without that formal gastroparesis diagnosis based upon that stomach emptying studying, it might not be as strong as the case as we were thinking. So this really allows us to focus in on the type of injuries and the type of cases we're going to have filed here in the MDL. I could see some state court litigations popping up now, maybe where we could get some of these other injuries included. But beyond that, we got a huge ruling and a huge victory for plaintiffs. Defendants, as they always do, tried to file a motion to dismiss all of the complaint. We pretty much beat back everything. We lost a couple claims that we do lose on occasion, but the majority of the claims survived the motion to dismiss. So we're moving forward on that, focusing really on the gastroparesis claims and then getting ready for the Daubert and preemption argument that still has to come before the end of the year.
Just to clarify, so I'm hearing you correctly. So if a claimant has a diagnosis from a doctor of gastroparesis, that no longer counts as part of this MDL. They need to also go get a secondary study that shows the stomach emptying to validate that diagnosis from their doctor.
Yeah, that's pretty much right. Like you said there, Mark, what the defendants were arguing is you couldn't have a clear diagnosis of gastroparesis without this study. So a lot of times we see diagnosis performed across medicine on a differential diagnosis. They look at symptoms, they rule in, they rule out causes, and then they end up with the gastroparesis. Now the judge ruled basically you need this proof, you need this additional layer to show that you have this correct diagnosis. So definitely a win for the defendants, but a lot of these claimants do end up getting that diagnosis because maybe you were seen by your PCP and they were unclear of what to do or what was causing your problems, and then they send you for that study. So
I sent you to a specialist, and the specialist did that study to diagnose them with that.
Exactly. So a lot of the clients already have this, but those secondary injuries might be a little bit harder now to prove because if you don't have that stomach emptying studying for the gastroparesis, it could be an issue to get those included.
Do you have any idea what percentage of the claimants that possibly this might affect?
In my inventory, I can't speak for everybody. I see about 65 to 75% of the people that have the gastroparesis diagnosis underwent that study.
Okay, so majority of them already had it done.
Yep.
Are you seeing any roadblocks in the other injuries, the non-intestinal injuries, whether it's blindness or anything else?
Yeah, so the blindness, the eye injury litigation is being handled separately from this. So this MDL is only the stomach injuries, the intestinal injuries. Really, like I said, it's zeroing in on the gastroparesis with 95% of the filed cases focusing on that. The vision loss cases, those are pretty much going on in New Jersey State Court. I think we talked about it on one of the prior episodes. So that multi-county litigation, MCL, just got formed and it's getting underway here. So we'll see that pick up. But recently there was a filing in Delaware with about 100 claimants. So that's going to be one of the state court avenues that we'll see for some of these other injuries as well.
Moving along, AFFF and PFAS. We got some updates here. CMO 35 entered on August 15th in the MDL. This sets some very important deadlines and requirements. What does everyone need to know about this order?
Yeah, this is a huge order that just came down and everybody should read it and be aware of what's in it. But basically, we were getting pretty far along in the mediation and then the defendants were saying there's a lot of unfiled cases that firms were inventorying. So the judge called in leadership and then ultimately entered this order, CMO 35, and it requires everybody who's on leadership in the steering committee to file all of their cases. And then it also sets some deadlines for serving the fact sheet and the type of proof that's needed. So basically what we have going on now is between now and September 5th, people have until file their cases. After that date, there's going to be additional requirement to serve a case-specific report within 120 days of filing. But if you file the case between now and this September 5th deadline, you can do a bundle complaint, what we refer to sometimes as a multi-plaintiff complaint with up to 150 plaintiffs in one case. Typically in the MDL, you weren't allowed to do it. You had to file each case individually. And then their requirements that you need basically is proof of one of these top 6 injuries. And then if you're alleging that it's a water drinking case, you have to provide the ID for that specific water facility that you were getting water from and were contaminated from. So it helps the plaintiffs by allowing us to do the bundle complaints. Kind of limits a little bit of the discovery that's required within 90 days of filing the complaint, but almost cuts off the litigation after the September 5th deadline. And then that additional requirement of the expert report thereafter.
It's an important deadline. We'll probably see case acquisition slow down significantly, probably pretty soon, right? Because if these cases have to get filed by the first week of September, you got to start working on them now.
Yeah, certainly. And, you know, we have the holiday coming up as well. I know a lot of firms already stopped taking cases or have a deadline in a couple more days. There's definitely an option afterwards. Those severe injury cases, I expect those tier 1 injury, kidney and testicular, to continue coming in, because the science is very clear on that. But yeah, those lower tier cases, I could see a fall off. But I've been watching the docket filing. We're seeing hundreds of cases filed each day. We have about 11,000 right now. I could see it getting up to 17, 18,000 before the deadline.
What's the next step in that litigation after the September deadline?
Right. So towards the end of September, we have the Daubert hearing. So that's at the very end of the month where we're going to be arguing which one of these top 6 injuries really are compensable or viable. Seems like there's no doubt kidney and testicular tier 1, they're going to be in. Very favorable signs on ulcerative colitis and thyroid disease tier 2. But then the tier 3 cases, the liver and thyroid cancer, it's unclear how the court's going to rule. So people are saying sometime before this Daubert hearing, that would be the time for the defendants to do a global settlement, get all of this resolved, because if they get an unfavorable ruling on one of those tier 3 injuries, that's going to bring about the opportunity for a ton more claims down the line.
That's big news. You know, we're finally having so much progress across all these litigations where things are really coming to a head in the next few months. It sounds like our upcoming episodes of Tort Talk are going to be very interesting and important for people to stay tuned and keep up to date in what's happening here so they understand what's going on, both in the cases that they are acquiring and in their existing dockets.
Yeah, a lot going on right now. Kind of the dog days of summer are behind us and everybody's getting back to it. So September is usually the busiest month of the year for us. We'll have a lot of really big developments and we'll keep everybody updated here on Tort Talk with Jon and Marc.
Awesome. Thank you, Joe. Fantastic episode. Lots going on, and go enjoy your honeymoon.
All right. Thanks, guys.
See you later.
See ya.